Hey there, welcome to Boss Talk. My name is Carey Sobel. I am joined with my business partner, Jim Parker, and we help people buy and sell businesses. And today's episode is the legal side of selling a business. And thus we have a good friend of mine and a professional acquaintance of mine, Mr. Ryan Cipparone. How's it going?
Very well. Thanks for having me today.
Appreciate it. Tell us a little bit about you and what you do.
Sure. So I co-founded Cipparone and Cipparone in 2013. Started off as a litigator, fighting in court for the first couple of years, realized that wasn't really my cup of tea, and converted to a corporate and business attorney from there. And since then have primarily focused on M&A transactions, representing sellers for the most part for companies that are lower to middle market.
Awesome. And we've had the privilege of working together in a couple different capacities.
Several deals, yep.
And it's going to be fun to talk about some of those today. So I think something that's really important is that, most buyers and sellers feel like when a deal gets under LOI, that the hard part's done. And I think we can all agree that the hard part is from there to the closing table, actually getting it across the finish line, right?
Yeah, absolutely.
And the amount of work that gets done during that period is where I think a lot of deals go off track. I always tell sellers, the easiest part of the M&A space is finding a buyer. And, negotiating to get to an LOI stage or to get to an asset purchase contract stage is also not as difficult as it is to actually get to the closing table. So I want our audience to really understand what goes on in an M&A transaction as it relates to the legal side. So anywhere where legal comes into play, which really should be from the beginning, even before somebody wants to sell, right? So let's talk about the different legal roles in a transaction. You said you like sell side, right? So you
That's
like
correct,
representing sellers. But there's also deals that you've done even with Boss Group for us where you're a third party, attorney.
Correct. So closing agent just facilitating the transaction.
So
exactly.
What are the differences between those two?
Well, from a buyer or seller standpoint, if you're actually representing the interests of one of the parties to the transaction, it's a completely different animal as opposed to jumping in as a closing agent and following the roadmap of the asset purchase agreement and putting those documents together that will actually get the transaction through closing. From my standpoint, especially from a seller standpoint, you always want to have the lawyers involved well before you're even thinking about selling, just because there's so many different issues that may pop up once buyers start looking into, they're looking under the hood, trying to figure out what's going on with the business. And a lot of times these sellers, they don't have everything buttoned up. And there's a lot of explaining to do, a lot of unraveling to do that you got to do in order for you to even get under LOI and get underway with everything.
Yeah. I'm thinking about one of the deals that we're actually working on right now where it seemed pretty straightforward. And then we're on the call and the seller just kept going, oh, and then I have this contract. Oh, and then I have this kind of half-assed employment agreement. And then I have this. And you just go, anything else? So I think when a seller is planning to go to market, regardless of the size of their business, prior to doing so, and we've talked about this all the time, assembling your M&A team. Well, your M&A team is your M&A advisor. It's a tax strategist, not just your CPA, and having a damn good attorney that specializes in M&A or selling a business, right? I think that's what you kind of need before you go to battle.
Yep.
Let's talk a little bit about kind of, the different roles in a transaction. And, Jim, we consider ourselves upper Main Street, lower middle market, right? We're about $2 to $10 million is kind of a specialty for us. And when I first got into this space, I didn't even realize that there were times where buyer and seller had their own attorneys and there was no third party attorney. So a lot of the Main Street transactions, what do we typically experience?
Yeah, Main Street transactions, usually just a closing attorney. I mean, we always recommend that buyers and sellers do hire another attorney, but, it's usually just, unfortunately they don't. Usually it's just the closing attorney. They're trying to save costs. When we're doing deals in Florida, it's nice because we use that BBF asset purchase contract and it kind of spells everything out. And it's a very fair contract. When you read it over, we've had a lot of attorneys over the years. I don't know how you feel about it, Ryan, but we've had a lot of attorneys reviewed over the years, and I've had comments come back from attorneys. It's very, very fair. I mean, it does. It looks out for both parties. It does weigh a little bit more towards the buyer than the seller. The buyer has a little bit more to lose than the seller does, but it's a very, very fair contract, and that's what I've heard from attorneys over and over again. So at that point, we use a closing attorney like Ryan. And he's not representing the buyer, not representing the seller. He's just, making sure all the legal ends are done, the lien searches, all the paperwork's done correctly and things are filed properly and, everything like that. So,
Yep. So I'd agree, it's a very neutral contract, but you also got to look at these deals on a case by case basis, because sometimes there's going to be certain issues within a business that maybe the BBF does not take into play and maybe the brokers just aren't aware of.
Yep.
And those conversations aren't had with the parties to where you got to be driving in additional terms to the BBF. Sometimes buyers and sellers will come to the closing table and just say, well, how's this going to work? I have certain jobs that are midstream right now. What am I going to do with that money for the amount of money that I've put into that job already? So, well, yes, I completely agree that the BBF contracts have their place when you're talking, $500,000 deal, maybe up to $1 million.
Yeah.
It definitely helps streamline that entire process for sure.
yeah. But it's always good that you should always have an attorney involved, even if they're just reviewing the contract, 'cause and I think it's not bad when you're dealing with a business. And Ryan, tell me if you think otherwise. You're the legal expert, but if you have a strong business attorney that is not an M&A person and you're selling your business for a couple $100,000, it might be good to go to that attorney because they probably know your business more. And it's more about, at that point, making sure that there's nothing missing in the BBF contract, nothing that needs to be added or anything like that.
Yeah, no, I agree. You don't know what you don't know.
Yeah.
So if there's questions being asked of whether you're representing seller or buyer, that's going to at least get the wheels turning to say, oh, I didn't think about that. Let's go ahead and address that now rather than us sitting down at a closing table and it comes up.
I think a good question is, when does it make sense to have a neutral third-party closing attorney instead of, representation on both sides? Because we always talk about on the show the difference between Main Street and M&A. It's not really a number. You could say it's a number, and $1 million, $2 million, anything above that is probably more of an M&A structure, maybe even a little bit higher. But it's really about the type of buyer that's coming in and that business, right? So when does it make sense to have a neutral third-party closing attorney?
I think especially when you're using the BBF contract and you have just like maybe a straightforward asset sale, makes sense to have it. But once you start getting into the M&A world, it's just buy side's attorney, sell side's attorney will handle it all the way through closing.
Yeah.
And there's no third-party closing agent or anything like that.
And in these deals, when it's a smaller deal, I feel like the seller's a little bit more cost conscious, right? So one of the things they always say to us is, what's your fees and what other fees can I expect? Well, you're going to have a third party closing attorney. And like you said, doesn't represent the buyer or the seller. They represent kind of the transaction. And that cost is typically split between buyer seller. I've seen it as low as $3,000. I've seen it as high as $10,000. But when you're talking about an M&A deal, each side is paying significantly more money than that. What makes it cheaper is it's a set of fairly standardized documents, right?
On the
BBF contract.
contract
BBF
side?
contract.
Yes, absolutely.
Yeah. So, let's talk about some of those documents that protect buyer and seller and whatnot. So, some of the basic ones. You have your bill of sale. You have your indemnification agreements.
Non-competes.
So the restrictive covenants,
Restrictive
protecting
covenants.
buyer on that. Yep.
What other documents are we missing?
A couple affidavits from the seller and the buyer, just they're going ahead and stating under oath that everything that they've provided to either party is accurate and truthful, so that you have a document to rely on later on if you come 6 months down the road and there's something that you find out once you're actually in that business, that you got something to say, well, I got some recourse here under these documents. Sure.
And, we've done a lot of closings together, but we've also worked with, Deborah Carmen and Ken Gluckman, a lot of other attorneys. And I do see a lot of the similarities between the different sets of closing documents from third-party closing attorney to third-party closing attorney. When you get into the M&A space, it's almost a completely custom transaction every time.
Absolutely. Every time. And buyer drives that often because they're usually the ones that are drafting up the purchase agreement once it gets to you. So usually once it gets, if I'm representing the seller, once it hits my desk, we're just negotiating it and redlining it from that point.
So maybe let's walk through each way. So if we're talking about a Main Street deal where you're a third-party closing attorney transaction, you're going to have buyer and seller. They're going to get into a purchase contract from a broker, whoever they're working with, and then that's going to get sent to a third-party closing attorney. They review the contract and then draft the documents based off of the purchase contract.
Correct. We're usually notified upon signing of the asset purchase agreement, and most of the times you'll see some sort of an escrow deposit that's going to be coming over and sitting in our escrow account until closing. And then what we'll do is we'll just map out when closings to occur, and then we'll make sure that we're getting our closing documents, at least the drafts, out to the brokers or to the parties, whoever it may be representing either party for review, and it's an easy close from there. Depending on, if you have SBA involved, there's sometimes some more work that's going to go into that where you're dealing with a lender as well because they have the specific documents that they need in place in order for the close. But yeah, it's fairly standard the whole way through on those.
Straightforward and easy. I like those ones.
But deal size doesn't make that any easier too.
No.
Sometimes those are the most complicated.
Yeah, I would agree. I actually, we did a deal in February together, and it was probably the smoothest transaction I've ever had. And it was 7.2, 7.25. I sold another business in January of the same year. It was a $500,000 transaction. I'm still dealing with issues today about that.
Yeah.
I mean, it's just crazy. The bigger deals, you have professional buyers, you have well-educated sellers, so they're kind of coming up to the plate where they know what's going on. So a good segue into a larger M&A transaction. So what is sell-side representation?
Well, I mean, that's a loaded question right there. Oftentimes, the best time to get counsel involved is no less than 12 months prior to even considering a sale. Just because you want to make sure that at least corporate structure, anything that's going on internally in the business, do you have pending litigation? How are you paying your people? I mean, for instance, we just went through a transaction that closed, but it was tough on my seller because once they got into diligence after the LOI stage, buyer finds out that this company's paying all these folks as 1099 contractors, treating them as employees, and it had a huge effect on the holdbacks that were part of that deal as well.
Bet.
So, then my seller's saying, well, you got to be kidding me. This is another 5% of the transaction price here on this. And they're doing it because they're concerned that they may get dinged later on based on some sort of a misclassification on how I treated these employees. And they wouldn't back off. So he was stuck at that point. That's a type of deal. And this happens often is that once these sellers get an LOI, they say, all right, I'm not sure exactly that this lays out what the deal is in my mind. Yeah. So now let's get a lawyer involved. And that's I would say 75% of how it works.
Yeah.
Now, if I'm outside general counsel for a lot of my clients, and a lot of them are selling now, that's great because I know the business. I know what's going on in the business. I've dealt with the principals for a period of time, so I know the personalities. I know exactly what's going on. And usually I've been involved in those conversations that have happened to get to that point.
And there may or may not have been any M&A activity for those clients where you're a general counsel.
Correct.
Right?
Yeah, where it's just kind of ongoing issues that pop up. They pick up the phone, they give me a call, and I know what's going on internally in the business.
Sounds like the ideal scenario for most business owners to have somebody like you that can rep them all along the way. I'm sure you've had clients for 10, 15 years that eventually decide they want to sell, and you happen to also be able to take them through the M&A part of it.
Absolutely, yeah. Small to large, 3 employees to more than 300 employees. Yeah. It's all across the board. And legal needs, they differ obviously on the size, but we're able to accommodate based on whatever the needs may be.
So closing a business transaction is more than just a purchase agreement. And we talked about some of the standardized documents that are involved in you being a third-party closing attorney. How does that differ in the M&A space?
Well, the purchase agreement, I'll start with that. Usually on the BBF contracts, you're talking 10, 12 pages on something like that.
Yeah.
You get in the M&A space, you're dealing with 60, 70, 80-page documents that are just riddled with reps and warranties that the seller's got to be given, the indemnity provisions that are loaded within those documents. And those are really the heavily negotiated provisions within there. And then if you're dealing with, rollovers and potential earnouts on the back end for post-closing numbers that these guys got to hit, there's a lot that goes into that from not only from a calculation standpoint, but also you got to think about it because sellers don't think of it. They see a number and they say, okay, I got to an enterprise value in this company at 20 million, call it. Well, you're only putting 15 million in your pocket at closing. Where's the other 5 going? And how is that? What's the contingency? Are you actually going to receive that at the end of the day? And there's a lot of stuff that goes into that where you got to put those explanations in front of your seller to say, hey, you may not get this $5 million. There's a possibility. So, my advice is always, do you know the buyer? Are you comfortable with the buyer? Especially if you're doing some sort of a rollover. Are these the guys for you? And then go talk to other sellers that they bought up. How's that experience been? Because the best thing that you can have is the information in front of you before you go and make those big decisions on that.
Before you make the big decisions.
Absolutely.
How often are you doing a deal probably sell side, where there is no broker, third party advisor?
Well, most of the time, I would say 80% of the deals, whether it's investment bankers or brokers, I would say that they are involved.
Yeah.
Sometimes you'll have strategics. I have a great example of this. This was a deal I did about 4 or 5 years ago. Large drywall company, and there was another company out of the West Coast that was probably double the size of them, but they had no footprint in the Southeast. And they wanted to come down here, purchase this company, and then blow it up from here to take over the Southeast as well. These guys contacted my group directly, and I had not represented the group before. It was a referral from another business that I had sold before. And they came in and they're like, we have no idea what we're getting ourselves into, but here's what we're getting. Here's the number that they're offering, and we want out. We can't beat this number.
Yeah.
And it's funny because these guys are in the drywall business, right? So they know how to hang drywall. And while they put together a business that was just an unbelievable business from a revenue standpoint, from a profitability standpoint, but they came in and they said, we have no idea what we're getting ourselves into right now. And while we have had a few conversations with them, we like this number. So my advice is always, let's pump the brakes here for a second. Maybe go get a quality of earnings because of the deal size that we're talking about right now. And let's just make sure that you're not leaving money on the table. Your eyes light up when you see these numbers, but let's do our diligence on the front end.
And they're pushing you for a fast close, and you're like, hold on a second,
To where on that deal, they said, absolutely not. We're not slowing up on this. This is our number. And I mean, you got to listen to the client. You can only do so much on that type of a deal. But, it went through. And it was 3 principals. 2 of them are done. That's what they wanted. One of them's still with the company today, running it on this side of the country, and they're all happy campers. So it was a good deal for them.
Was there any equity roll, or was it just an earnout?
Nope.
Or
this was a straight asset purchase agreement. And the group out west, they enjoyed going through the transaction with them. And I'm local counsel for that group over here now.
Awesome.
So it worked out.
So that's almost like it's a double dip.
Yeah, something like that.
That's very unusual. The seller staying on without rollover equity.
Nope. Yeah, and he's been there. I mean, this is 5 years now, and I still talk to them fairly regularly.
Good.
Yeah.
Good.
I have a whole section talking about reps and warranties. I think it's one of the things that, as you're climbing upstream and doing larger deals, is probably one of the most challenging parts of getting through a transaction. So we'll kick that down the road a little bit for this. But let's talk about what actually happens on closing day. And maybe even before that, let's talk about...
Maybe we should kind of go through the LOI stage, because I don't think the listeners may not understand the LOI, the definitive agreement, closing.
Well, let's do that. Let's start with the LOI, right? Because there's deals that we do where there is no LOI. We go straight to an asset purchase agreement. Usually a Main Street transaction. But let's talk about the LOI. And most owners believe that when an LOI is signed, that the deal's kind of done. And as
far from it.
It is, I don't even know what the right word is for that. Ignorant, right? Maybe.
Yeah. And I think also they when they sign that LOI, a lot of times they're like, I don't need legal representation. And it's just 1 or 2 pages.
It says non-binding.
Yeah, and they don't realize that's setting up the stage for the definitive agreement. And you can read that letter and you can be like, okay, everything makes sense. I agree with that. But an attorney still needs to review that, because one word can make the biggest difference.
Yeah.
And you got to make sure that everything that needs to be included in that LOI is included. I mean, from our standpoint, and yours too, Ryan, you don't want to be caught off guard when you start negotiating that definitive agreement and realize that the buyer and the seller are not on the same page with critical things. So you got to make sure that the spelled out or is in depth enough that we know that both parties are on page with major points.
So what exactly is an LOI, and what are maybe some terms that are drafted in LOI?
Yeah, and I agree with that point, Jim. You don't want to have egg on your face, is what I say. So sometimes I will get a client that comes to me after the LOI is already signed, and I've said, oof, we got ourselves a little bit of work to do, because then I've got to go and deal with buy side's counsel and say, my guy's not agreeing to this. He may not have understood it at the beginning. He just wasn't exactly sure what he was signing, type thing. And it's just not a good look, and it's not a good, especially if you have a strategic partnership and you've got a material term that you're now going back on, and you guys got to be partners after this. it doesn't start the partnership off right on something like that.
Yeah.
From an LOI standpoint, depending on the deal, but a lot of times I like to get as much as possible onto that LOI, just because us attorneys, we use this as a roadmap going through everything. Now on the M&A transactions, you'll have some general language. For instance, when you're driving in indemnity provisions within the LOI, you want to make sure that you have certain limitations on the indemnity, and you're putting in their language of customary transactions. You want to make sure that you have a limit on what they'd be able to pursue against you post-closing if there is a breach of a rep or a warranty. Sometimes you'll even go as far as laying out what reps and warranties may be lodged into the definitive agreements once you get to that point. It could get to that point. I've had deals where we've defined fundamental representation. So the big ones, the ones that should not be breached. There's a serious issue if one of those fundamentals is actually breached. But most of the time, you have your purchase price. If there's a rollover component to it, that's going to be explained throughout it. We'll want to know what holdco you're going to be rolling into. If there's an earnout component to it, that's a big one too, because what you want to make sure is that you actually have a calculation as to what that earnout is going to be based off of. Because once you get to a closing, in a definitive agreement, my preference, most lawyers that I deal with, this is the preference, is that you have an exhibit or a schedule that lays out that calculation so that everybody's comparing apples to apples, and that when that time comes, whether it's a year later, 2 years later, maybe it's both, whatever it may be, you're just dropping numbers into a calculation. So there's no manipulating or playing around with those figures. Now, some groups, if you're dealing with, for instance, like a net profit type earnout, the buyers have the ability to manipulate those numbers.
Oh, yeah.
So, there's a lot that goes into the LOI. Exclusivity is a huge one for the buyers because they don't want their sellers going out and talking to other folks, because, if a seller hears of another buyer that's just willing to offer a little bit more, they start thinking,
Yeah.
And that could become a problem too.
I see the buyers are always trying to get people locked up as soon as they can into an exclusivity period so they're controlling the deal. But we typically push back a little bit on the seller side, at least in some of the deals we've done together, making sure that every single thing that we possibly can get into the LOI, we do. You do the work one way or another. It makes more sense to do the work on the LOI and create that roadmap. You then create your asset purchase agreement that much faster because you've negotiated most of the terms.
And there's a lot less friction in there too, because you guys have already agreed with things up front.
Yeah, well, most of them are non-binding. They do protect, exclusivity and certain things like that, but I just think if people are going to, buy side and sell side are going to agree to go under some type of agreement where they're agreeing to work with each other exclusively, why not get most of those terms done right then and there as opposed to doing it later?
Yeah, to the extent you can. There's going to be confirmatory diligence that the buyer's going to go through. If something comes up that wasn't brought up to them when they were going through initial diligence, when they were under an NDA, then they're coming back and they're having a conversation to say, well, we've got to change this based on what we've since found going through diligence.
Yeah, but if you're avoiding terms of an employment contract, terms of a restrictive covenant or a non-compete, you're leaving those things out. These are major items that should be core, in every single LOI.
Absolutely. And especially if you're looking for these principles to be staying on as well. Sometimes we'll even go as far as laying out their employment terms as what that looks like for us to drive into an employment agreement as part of one of the ancillary documents at closing.
I want to back up this. The sellers a lot of times, and I don't know how you feel about it, Carey. A lot of times the sellers worry about that exclusivity part. I kind of look at it from the intermediary standpoint that as soon as we go under that LOI, I want to pull it from the market. I want to pull it immediately from the market, because if the deal does blow up down the road, I don't want that listing to get stale.
Yep.
And a lot of times, the other thought is, we can just keep collecting information. We can keep collecting buyers' contact information and we can hold it. But I look at it as, most of these buyers, they're going to, okay, it's under contract. They're moving on. They're not thinking about it. So I just think the listing goes stale. So I'm like, yeah, let's pull it. If it blows up a month and a half later, which hopefully it doesn't, we take it back to the market. It's fresh. It's hard. We can get the buyer's interest back up.
Share the same perspective.
Especially how quickly we're getting them under contract too. Because that sometimes you're not getting the complete exposure of all the possible potential buyers, because we're getting so much interest in the listings.
And to be frank, it's annoying.
Yeah,
we Ryan and I are working
it's just
on
busy work.
We're working on a transaction right now. We generated 350 NDAs. We got 48 LOIs, narrowed it down to 12, met with 5, picked 1, and I still have all 48 of those people reaching out to saying, what's going on, what's going on, what's going on? Well, we're still not at this point today in an executed exclusivity agreement under LOI. So I can still talk to other people and let them know, but I don't want to. I feel pretty good like we're going to get this one done. So I want to have a nice 1 or 2 backup offer, pull it off the market, keep them abreast of anything that goes south during negotiations. And if you have to put it back on the market, you do.
Yeah.
But conversation for another time, most of the good deals never even hit the market.
Yeah, that's true.
You know, but okay, so we talked about the LOI. Before we go to APA, the asset purchase agreement, what is the LOI trigger? What's the next step when you typically get an LOI done?
Diligence. Yeah, typically buyer's going to send over their diligence list depending on the buyer. And this is I call it the sticker shock. I try to get my sellers ready to go and understand what they're in for once it comes time for diligence, because it's an overwhelming period for them. They don't realize that if you got a single owner can't handle a lot of this diligence just on their own. So whether or not they have a deal team or a third party that's assisting with diligence and going through that process, or if they bring on some key employees and maybe they don't want the entire business to know what's going on and that they're under an LOI and there may be a sale, because it does scare some employees just because of the unknown.
Yep.
But, I tell them we're going to need at least a small team together to get us through diligence, because not only are you going through diligence, you also got to run this business.
Yep.
Which takes up a lot of time as well. And, I've had sellers pulling their hair out, and it takes 3-4 months just for them to get around to getting everything together. So if you're not an organized company and you don't have everything buttoned up, and buyer keeps coming back to you, for financial information, for legal information, insurance information, it takes up a lot of time.
And that's why, when you're starting to prepare to sell 2 or 3 years before you're ready to sell, you start preparing for that. You should start getting yourself organized, making sure you know where your tax returns are, your bank statements are, your merchant service statements. You know everything they're going to ask during due diligence, so that when it does pop in and due diligence begins, it is not such a headache. And I experience with the sellers a lot of times that, like you said, they don't want their employees to know the business is for sale. I mean, that's 99.9% of the time. And so they can't pull that information during the workday. So a lot of times, I don't know what you experience with your clients, but a lot of times my clients are going in on a Saturday and a Sunday, and they're gathering that information. And they just need to be aware that it's a lot of information that buyers ask for.
And the due diligence period, I mean, I've had pretty simple ones because seller was very organized and we just send over a data room of everything, check their boxes, and we move on. But rarely is it nice and seamless. So if due diligence is where a deal gets tested, what do you see as some of the issues that are coming up? And maybe even before that, what's happening during due diligence? It's not just financial due diligence. And a third question, if you remember all 3 of them, how involved are you in the due diligence process?
So usually you'll see there's legal diligence, financial diligence, and just operations type diligence that they're going through, the buyer's going through. And it's a document dump, and the buyer's going to have their third party teams ripping through everything. So a great example that I gave earlier with regards to a potential misclassification comes up in diligence. They want to see exactly how these folks are being paid and exactly how they're treating them as employees. So potential issue there. Tax items. So if sales tax not being paid, if they see that there's an issue with that as well, that's coming up. From a legal standpoint, it's really just about the corporate structure. They want to see everything from, if you're an LLC, you got an operating agreement. If you're a corp, you have a shareholder agreement. They want any minutes of the company. They want to know exactly if there are any subsidiaries out there that these companies have, because especially on an equity deal, there's a lot. In an equity deal, you're taking the good, the bad, the ugly. So they need to know everything. And it's usually a little bit of a heavier lift when it comes to diligence on that. Are there any pending litigation matters going on? Buyer needs to know that, because if it is an equity deal and you're stepping into the shoes of that seller, you're along for the ride with that. And they're going to be looking to carve that out in one way or another, just to make sure that they don't have the liability going forward.
What percentage of your deals are stock sales and equity deals compared to an asset purchase?
I would say probably more than 50% are stock sales.
Yeah.
Yeah, absolutely. And for different reasons. Sometimes you have licenses in place that the company holds a license and they don't want to have to go through the pre-approval process of going through that.
Yep.
If there's government contracts associated with that company, then although you're going to have to go and get the consent of whatever governmental body that you're looking to do business with going forward, but I would say more than 50% of them are stock sales.
Yeah. And Jim, when I first started in the business, they were all asset sales.
Well, yeah, the smaller deals. Yeah.
Are you seeing more of yours now also?
Well,
equity deals?
no, not really. I work mainly in that $1 to $5 million space, and I would say about 50% asset, 50% stock.
Okay. That's still more than I was expecting you to say.
Yeah.
So we're in due diligence, and you had mentioned quality of earnings, QOV. What percentage of your transactions do you see at QOV?
Probably 50%. Again, depends on transaction
Size.
value and the size of the business. I have a couple of folks right now that are considering sale, and they are going through the QOV process right now. And the
Well
benefit there is that you get the information in front of you, and you get somebody on your side to tell you what your business is worth, rather than having some private equity firm come in that's already gone out and hired a third party, and they're doing their QOV on you, and they present it to you, and they say, here's what your business is worth. A lot of these business owners, they're not going to be able to understand that
Or
and
defend
realize
it.
exactly.
Yeah.
So now you got something to rebut what they're going to present to you.
Yeah.
And I've seen it work. I mean, there's a lot of value that comes along with getting a QOV.
I've seen people get 3-4 extra turns just by getting a quality of earnings.
Yep.
So I always encourage my sellers to do that from the beginning. But even if you are representing somebody that didn't get a QOV before they went to market, buyer's almost always going to do some form of quality of earnings.
Absolutely, they have to.
And that's coming up during due diligence. But how often do you see a deal getting renegotiated during due diligence?
Unless there's something glaring that just comes out where it was not brought up initially, which is another big thing for sellers, is that I always make sure to advise them, be transparent up front.
Yes.
Don't deal with it. It's going to come up. They're going to find out.
Yeah.
And the last thing that you want to do is be a day or two before closing, and then the buyer's got all the leverage at that point because you've just gone through this exercise, and the time and the money that you've spent, now you're gonna fold.
Yep.
And you're gonna say, okay, I get it. This was going on. It wasn't brought up during diligence, and now I've got myself a problem. So, to go back to the question, it's all about transparency. Deals being renegotiated, it doesn't happen a lot so long as everything's coming out on the front end.
And I'd like to go in deeper with what Ryan said. That is such a critical thing, that everything is transparent up front. When buyers find out things in due diligence that they haven't been told about, they lose that trust factor. And a lot of times that is what will blow up the deal.
Yep.
It's very, very important that when a buyer is buying a business that they like and trust that seller, and the minute that they go into due diligence and something pops up that they found out on their own, they lose that trust, and that jeopardizes the deal.
When we build our relationships with people selling their business, we're asking them all of those things up front, saying, hey, we're not the people to hide.
Tell us the skeletons.
We need to know.
Because that way it's easier when there is something, because no business is perfect. And if there is a negative about the business, first of all, that's the honest, ethical thing to do, is to mention it up front. But it also gives you the opportunity of, okay, that's going to be an obstacle that we need to overcome in the sales process. And that way you can how are we going to overcome that obstacle, instead of a buyer just finding out and we're getting caught on. And that's the worst thing. I hate that the most, doing a deal, is being caught off guard because I wasn't told something by a seller up front.
I think we do a pretty good job extracting that out of our sellers.
I think we do
We
too.
also take the step forward that when we're representing the business and bringing it to market or talking to buyers, we're also calling out those red flags.
Yeah.
Hey, this business is great. It's got X, Y, and Z, but their largest customer represents 35%.
Yeah. And sometimes we have to do it, sometimes we'll talk about it in the sim. And then other times we're like, okay, that's not the appropriate time. Maybe we wait as long as, right before somebody's going to put an offer in, or they put an LOI in, because maybe you don't want to let every single buyer know about that particular issue.
Yeah.
So you kick that right down the road, but that should be disclosed to a buyer before a signed LOI.
Absolutely. Without question. So we made it through due diligence. Congratulations.
Yeah.
All right. We're getting to closing. What's closing day look like? Because I think sellers probably imagine, having that really nice pen and putting their John Hancock on it, and then boom, money comes right in.
Yeah.
Don't work that way.
So, well, there's a step in between that as well too, with the negotiation of the definitive agreements, whether it's a stock sale, equity deal, asset deal. So that's usually when the lawyers are heavily involved. The lawyers typically aren't too involved in diligence, but usually I'm getting the intros over to all the lawyer team at that point. And we're going through the negotiation of the purchase contract. And, depending on the deal, most of the times you're able to get through something like that if it's 4 or 5 turns on a purchase agreement.
Yeah.
But majority of the deals, M&A, they're simultaneous close. So you're signing a purchase agreement and you're closing that transaction same day.
Yep.
And, it's funny because sellers are always like, so, day before close, what am I in for tomorrow? What does this look like? And we're either setting up a call, setting up a Zoom call. And I said, honestly, it's extremely anticlimactic.
It
Yes.
is. Everybody thinks it's this big, it is. Very, very much so.
So, and everyone's a little bit different. Sometimes I've had buyers where, you've got a massive company on the other side and private equity backed. And I had a guy dropping emojis with, confetti all over the Zoom thing. And my seller's like, what is going on with this?
Also, everything the buyers and the sellers have reviewed all the documents. Everything that's done is done days before due diligence. Before closing. So there's no surprises. Everybody knows what they're signing. It's just, it's not, like you said, it's not very climatic.
Well, like Ryan said, if you have 4 to 5 passes of the asset purchase agreement, for one, let's say you did the right diligence up front in the LOI. It's kind of spelled out the guidelines of it. During that, you start working on your diligence. You're moving towards your asset purchase agreement. If you're taking your asset purchase agreement over a month, 2 months, I'm sure sometimes 6, 7 months, it
Could be.
You're negotiating all the little bits of it as you go. So if there's any issues that come up, they get addressed head on, and then if you get past it, you keep going. But how many times during that does a deal die?
Hopefully at that point there's been enough diligence done by the buyer that they know enough. At least they've peered through the window. They understand what's going on. I've been fortunate enough to where I have not seen a deal die after receiving the purchase agreement from the buy side. But it happens. Things could change, even if it's market conditions. If buyer just gets a little bit freaked and they say, stuff has really changed since we began this process. We're not so sure that your company's worth what we thought it was worth.
So the deals don't die, but perhaps the seller has to give some concessions because of A, B, or C. But usually they're pretty fatigued at that point. And like you said, maybe they didn't call out a skeleton in the closet. And they realize, this is kind of the best I'm going to get. I just worked with this group for 9 months. I just spent $50,000 and everything. And let's just close it. Take a little bit of a haircut.
Yeah, so you try to knock your sellers out of that mindset to say, no, let's stick firm and let's push through, because buyers have also, they're committed.
Yeah.
And while they could walk, that's a possibility. Why take it on the chin at that point?
I had a transaction last year up in Georgia, situation like that. About a week before closing, the buyers were trying to retrade some things, some items. And I was really proud of my seller. Me and my seller were on the phone for about an hour. Talked with his attorney too, him and the attorney as well. And the seller held his guns. He was ready for the deal to fall apart, ready to go back to the market. The private equity group / industry players, they caved and they went back to what it should have been. We ended up closing.
Yeah, I've had that conversation many times with sellers. Yeah.
I told him, like, if you're going to do this, you're playing chicken. You got to be ready to crash the car. And he called me back and he goes, I'm ready to crash the car. I'm like, good,
What are some of the biggest legal mistakes that sellers make? And I know that's kind of a difficult one, but anything that you can think of.
As far as pre-close or during the process?
Anywhere.
Okay. I would say, sometimes these guys, they just don't know. For example, I've walked into seller companies before on an asset deal, for instance, and we're running through everything and I get engaged late. Come to find out, they have 30 pieces of equipment that all have title, but it's in the individual's name. So then you're going through and you're transferring out of the individual's name in order to get it into the company's name to make it part of the transaction. It's just stuff that they're not thinking about. Engaging outside CPAs to do your books. Some of these companies, if they're just using QuickBooks, it can completely change your numbers. So not necessarily a legal issue, but those are two of the issues that I have seen pop up a lot. Sometimes if you have pending litigation, or if you have maybe there's an issue where you've got 5 customers, and they each represent 20% of your business, and something's coming down the pike with one of them, and there could be a potential for some termination of that contract, or you got a renewal coming up. You better make sure that you're keeping those guys on board.
Yeah.
You better spend a lot of time with them as well, because there's a lot of value that goes into that as well.
So you can group everything into just being prepared.
Sure, absolutely.
Right?
Preparation's key.
Every single one of those items, you sit down with somebody and, say, I'm going to go to market. Help me figure out everything that could come up ahead of time. I have a lot of sellers that are very apprehensive about signing that engagement agreement with the attorney until they're under LOI. I don't think that's the right play.
Well, like I said, the earlier the better, but, I'm often the last guy to the table. They've got the brokers involved. They'll have the CPA, whether it's their standard CPA that they use for filing returns and handling on the monthlies, putting the financials together, or outside. And then it's time, they say, okay, let's button it all up. Let's get the lawyer involved at this point. So I'm usually the last guy to the table.
Fun. So, lots of legal mistakes that can be made, across the board. But advice for sellers who want to sell in the future, again, comes back to just be prepared. But what type of things should they be looking at? I think maybe you can start with corporate structure, right? So, we were doing a tax presentation, and the way you set your company up, all the way down the end, could completely change your tax ramifications at the end, and you may not know that until the end of a transaction. Right?
Absolutely.
So you're probably going to advise in there and step in. How are you set up? How's it structured? Do you have your articles? Do you have your op agreement?
So we'll want to see the complete organizational structure of the company and make sure that you're actually running it properly. I mean, I've seen companies before that were going to market and they're commingling assets with other companies if they have real estate involved. What's that structure look like? What's the umbrella look like of all the companies? Because it's usually not just one company that these guys have. And if they're running funds through multiple companies, that it looks like, and it's now in turn increasing what it looks like in revenue from the actual target company that's being sold, that's a big issue. And now you're going to be taking that out of the equation, and it's going to have an effect on your enterprise value on the company.
But you're not going to see that as an attorney.
Nope. Those are just the questions. What do you got?
Yes.
Show me an org chart.
Where's the hair?
Let's make sure that, and I'm getting on the phone with the CPA, and we're running through everything just to make sure that everything is aligned as it should be.
So are there types of levels of engagement that you offer on kind of like a sell side?
Yeah, so, we're a boutique firm, so I can accommodate, and depending on what seller's looking for, I'll have those conversations up front. Majority of the time, they're the ones that are dictating what they're looking for out of me.
Yeah.
And then I'll just offer them options to say, hey, look, here's what we can do. You tell me where you want me and when you want me to jump in. And I'll let you know if we're going through the deal. If there's something that I think needs to be addressed, I'll bring it to you, let you know what's going on. And more often than not, once we get through negotiating out an LOI, they're telling me, you run with it from here.
Yeah.
You lead the charge.
Is there anything you draw a line in the sand saying, I don't want to do this, whether it's a dollar amount or an industry or anything specific that you like to stay away from?
I haven't, maybe certain industries, nothing tax related. Sometimes on the larger scale deals, I'm bringing in the tax folks to make sure that they're taking a look at everything as far as any unknown tax implications. I don't practice tax law. I don't give advice on tax. So industry wise, I have not had anything that we've said, no, not interested. Once you start getting in the medical space, that's usually where I'll start kicking it out just because of HIPAA violations and that kind of thing. But no, nothing industry-wise that we have not been able to handle. I mean, we're all across the board as far as industries on target companies.
So seeing so many transactions, what separates a deal from kind of going smoothly and not?
I'd go back to preparation.
Yeah. It's all going to land there, isn't it?
Absolutely, yeah. And as long as the seller's committed, sometimes you get sellers that will tell you, I think I want to sell. And then they get into the process. They get to know the folks that they'll be possibly working with later on down the road. If there's a little bit of a rub there starts to get, in the back of their mind, am I really sure I want to do this?
Yeah.
Or if they think they're leaving money on the table, they say, I shouldn't have gone through it this way. Those are some of the, things that we've dealt with going through these transactions before.
What's the hardest part of doing a deal from the legal side?
Personalities. Every deal has its own, the folks that you're dealing with are the personalities to where you got to know your players, who you're dealing with, and how to take it. Most of the times, a lot of times the lawyers that I'm dealing with, they're the national firms, right? Or even larger than that sometimes, to where there's 7, 8 lawyers on the Zoom calls, just because buyers have a lot more to go through as far as diligence. So they need all of their players and their professionals to come in and say, I got an issue here, I got an issue there. But there's usually one lawyer that'll run the transaction from their standpoint. So you got the personality of the lawyer that you're dealing with on the other side. You got your client or clients, depending on how many owners are part of that as well. And it's a highly emotional time for these individuals because most of the time this is their largest transaction that they're going to go through in their entire lives.
Yeah.
So
and maybe the first
rightfully
time
so, they're emotional about it. So.
And maybe it's the first time they're doing it.
Sure, they don't know what they're getting into.
Yeah.
So you just have to be there. It's a communication thing. We pride ourselves at our office to make sure that we're communicating the whole way through and we're not leaving them in the dark.
You guys do a damn good job of that.
Well, thank you.
I think when you're talking about the personalities aspect of it too, we play a lot of this in our space, because a lot of times, like you even mentioned, you come in afterwards. We're sometimes the first conversation when somebody's thinking about, I want to sell the business. We've been trained over the years and learned just the different ways to kind of find those red flags where maybe somebody truly is not ready to sell. We don't want to waste our time and get down the road. But I think managing the personalities, we're at a point now, we talked about this in a couple episodes ago. If we don't enjoy the people that we're starting to engage with, we just walk the hell away.
Yeah. No, that's important. You got to enjoy who you're working with because you could be in it for the long haul too.
Yeah. I know the answer to this, but you actually enjoy what you do, don't you? I
do. Just from the business standpoint, growing up with a business background and then putting the law component to that as well. I take a little bit more of an entrepreneurial approach to my practice. I have my own firm. I have other businesses. It's just having the legal knowledge behind that helps because, I'm not the lawyer that's just going to speak legalese the entire time and go through each legal point with my client. Rather, I can associate with them a lot better.
And it's a complete difference when you're working with. I don't want to have ageism play into this, but I think the younger generation of attorney who maybe did run businesses or can relate or has been in some realm in some type of enterprise is going to significantly they're going to approach everything differently.
Sure.
It's going to be easy to relate to them, to talk to them. But some of these old school attorneys, it is just that. It is straight down the middle, no personality, no conversation. They don't need the buttering up shit back and forth, but you do want to be able to enjoy communicating about the business, about the people, and building a relationship along the way.
Yeah, the last thing you want to be is miserable throughout an entire transaction.
Yeah. Trying to think of anything else we can cover. I mean, I think war stories would be really fun on the legal side. We share some of these, what we're allowed to, because, confidentiality is huge in our space. But, it really makes a deal fun when you can work with people that you like, especially on the legal side. I would like to share some of those stories in maybe a future episode, but what else do you think we need to cover on the legal side of selling a business?
I think we did Ryan, I think you did a great job.
Thank you.
I think we covered a lot.
Awesome. Let's do a separate one on reps and warranties because that's going to open up a whole can.
Yeah, that's going to be a long one.
Yeah. Well, Ryan, thank you so much for joining us today. We really appreciate it.
Absolutely. Thanks for having me.
Thank you, Ryan.
And if anybody is looking for a fantastic M&A attorney and business attorney, reach out to Ryan at Cipparone and Cipparone. We will have some information for you on how you can contact Ryan. And thank you guys for joining us on this episode of Boss Talk.